Hello, everyone. Today, I'm going to be talking about the Birthright Citizenship Clause of the 14th Amendment and the history, spirit, and issues surrounding birthright citizenship. Birthright citizenship is enshrined in the 14th Amendment of the Constitution of the United States, but birthright citizenship itself has a rich legal history that predates the 14th Amendment. The American right, however, is trying to erode that spiritual essence and legal precedent through bad faith interpretations turned propaganda, and now that Trump is president again, executive orders that are unconstitutional. The historical precedence of birthright citizenship largely takes form in two court cases. One by the New York State Court, called Lynch v. Clark, and another by the Supreme Court of the United States, Ingalls v. Trustees. In the case of Ingalls v. Trustees, an excerpt from that case reads,
"The rule commonly laid down in the books is, that every person who is born within the lineage of a sovereign is a subject, and e converso, that every person born without such allegiance is alien."
What this means is that everybody born in the U.S. who owes an allegiance to the U.S. is considered a citizen, but the Supreme Court did not clarify what allegiance really means in this case. However, a later court case from the New York State Court, Lynch v. Clark, which takes place 24 years before the ratification of the 14th Amendment, but an excerpt from this case reads,
"I can entertain no doubt but that by law of the United States, every person born within the dominions and allegiance of the United States, whatever the situation of his parents, is a natural-born citizen."
With this excerpt, Lynch v. Clark stands as an extension of what the previous case set up by clarifying a couple things for us. First, by clarifying for us that the allegiance of the child is not necessarily determined by the allegiance of the parent. In Lynch v. Clark, the citizenship of a person named Julia Lynch was called into question. See, Julia was born in the United States, but only during a temporary visit her parents had taken, and then was later raised in Ireland, her parents being British citizens. But the court ruled that the temporary nature of her parents' visit and the fact that they were British citizens had no relevance concerning Julia Lynch's citizenship. Lynch also clarifies for us that a sort of natural or permanent allegiance is imposed upon you when you are born. In fact, this is enshrined by law. It's called natural allegiance, and it is an obligation to follow the law when you are born within the territory of a country. In Julia's case, because she was born in America, she owed the country a natural allegiance even if her parents did not. And this was called into question, but still upheld by law in a New York State court. The historical precedent surrounding birthright citizenship before the 14th Amendment has words like allegiance and dominions in its language, but the 14th Amendment itself, ratified in 1868, is a bit more specific. The first clause of Section 1 of the 14th Amendment reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside." This tells us that, according to the Constitution itself, the criteria for being considered a citizen is 1. Be born in the United States, and 2. Be subject to its laws. However, the Trump administration thinks that temporary visitors and undocumented immigrants don't qualify for each of these criteria, and therefore neither do their children. Executive Order 14160 was signed in January of 2025 and attempts to limit the birthright citizenship of those whose parents are undocumented or temporary visitors and are therefore, according to the executive order, not subject to the law. This executive order was passed during a time of heavy criticism for birthright citizenship, coming from two main talking points. The two main talking points are, first, so-called birth tourism, which is apparently when people come to the country specifically to have kids, so their children are considered citizens. And the second of which is that, subject to the jurisdiction, applies to the parents first, and therefore if it does not apply to the parents, it does not apply to the kids, and undocumented immigrants and temporary visitors are such parents. I'll be addressing birth tourism first. So, Here we go. Birth tourism, they believe, is the main avenue for coming here and committing birth fraud, or to even replace parts of the American population by having kids here who are considered citizens. It's not true, but they believe that. To just give an idea about how ridiculous this claim is that in 2020, the amount of births within the United States that was attributed to birth tourism was only 0.2%. And annually, on average, it's only 0.7%. So you can see how there's a pretty big difference between the reality and what people are saying about what's going on in the US. And it's worth noting that this doesn't even consider the legal implications of birth tourism. That birth tourism doesn't bear any weight on the constitutionality of birthright citizenship for those who are born from parents who are undocumented or temporary visitors. It just isn't relevant to the constitutionality of that issue. That constitutionality is very important because the Trump administration would have you believe that the children of undocumented visitors and temporary visitors do not qualify for birthright citizenship because they're not technically subject to the jurisdiction. But this is false for several reasons. The first of which is the Constitution itself. The language of the Constitution does not place a focus on the parents, but rather the child. According to Cornell law, being subject to the jurisdiction of something means to be subject to the laws of the country that you're currently in. That subject to being of that jurisdiction is just saying whether or not you're prosecutable and protected under the law. And who is prosecutable? Who is protected? Well, the 5th and 14th Amendment have a due process clause that includes all persons. That means that all persons are protected by due process. What is implied when you are protected by due process? Prosecution. So, therefore, according to the 5th and 14th Amendment, every person in the United States is prosecutable and protected under the law. The second major reason is legal precedent manifesting in 2 Supreme Court cases. The first case, Plyler v. Doe, maintained that children born of undocumented immigrants can enjoy the government-provided service of public school, and a state cannot prevent them from doing so. This reveals for us that the children of undocumented immigrants are protected by the law, and thus their parentage is less relevant than the child status themselves. The only exception to this case was found in the Supreme Court case U.S. v. Wong Kim Ark. In this case, they maintained that the children of temporary visitors are, in fact, citizens of the United States if they're born here. The only exception is if their parents are diplomats or government officials, i.e., if they have diplomatic immunity. Because the Constitution includes all persons in both the 5th and 14th Amendment in their due process clauses, meaning every person is subject to the law, and the cases Plyler v. Doe and Wong Kim Ark protect children of undocumented and temporary visitors, with the only exception being diplomatic immunity, we can see that the Trump administration and the executive order trying to restrict birthright citizenship for those who are born of undocumented and temporary visitors is unconstitutional. However, there are still those who would consider these children to not be eligible for birthright citizenship. One organization, the Heritage Foundation, put out an article claiming that the children of undocumented and temporary visitors are not eligible for birthright citizenship because their parents owe an allegiance to another country and therefore not ours, and therefore their children would also not owe an allegiance to our country. To clarify, this is already pretty flatly wrong on its face. As we saw earlier, the 14th Amendment does not use the word allegiance. The 5th and 14th Amendment include all persons, and the current legal precedence does also not focus on the parents or use the word allegiance. So we're already kind of on a pretty rough start with this one, but we'll continue anyways. As we saw in Lynch v. Clark, natural allegiance is imposed upon you at birth and is not determined by your parentage, but rather your birth location, with the only exception being diplomatic immunity clarified for us in Wong Kim Ark, but we can still tackle this just for fun. There is a separate type of allegiance, that of temporary allegiance, that is imposed upon you when you enter a country, but that temporary allegiance is just an obligation to follow the law while you were within the jurisdiction of that country. But guess what? Temporary visitors and undocumented immigrants are not exceptions. And that temporary allegiance would mean that they are, for a time at least, allied with the United States. So, if we just extrapolate this, no matter how you spin it, whether you add in the word allegiance, whether you add in the word jurisdiction, whether you focus on the parents or focus on the child, it doesn't matter. As long as the parents are in the United States and the child is born with you in the United States, they are eligible for citizenship, no matter how you spin it. The Supreme Court is currently deliberating on this issue in the case Trump v. Barbara. It concerns the constitutionality of the executive order mentioned earlier that the Trump administration has passed, and whether or not those children do in fact qualify for citizenship. The oral arguments in Trump v. Barbara kind of indicate for us that the executive order was not constitutional. Birth tourism has already been thrown out as irrelevant to the case, and Justice Kavanaugh has already indicated that the 1866 Civil Rights Act, which does put a focus on the parents of those children, is different in both meaning and text to the Constitution, and is therefore also probably put into question. However, it is entirely possible that the Supreme Court will rule in favor of the executive order and its constitutionality. But such a Supreme Court decision that is in favor would be uncharacteristic of a court that has harped on originalism and historical intent, which can be found in the legal precedents I've laid out for you here. And if they do rule in favor of the executive order, that just highlights for us that this Supreme Court is captured by ideology and is willing to be in contradiction with itself in order to further the goals of the conservative movement. Overall, the spiritual essence of birthright citizenship has permeated this country's history for the past 200 years, almost. And a court which might rule against that, such a court that does, is in conflict with itself based on its own stated goals, that of originalism and historical intent. But we have to wait and see whether they will rule in favor of the executive order or rule against it, whether they will uphold the values of the Constitution or rule against them. We'll have to wait and see. Their decision comes in late June or early July.